Welcome to Groom's Investment Advice Hub. I'm Kevin Walsh, and I'm here with my colleague, George Sipsakos. Today, we're going to be talking about what it means to be a fiduciary. Welcome, George. So I guess the first question is, what is a fiduciary?
Thanks, Kevin. Fiduciary in our parlance is generally someone who has a duty to act on behalf of someone else. And in our context, we think about it in the context of retirement plans, in IRAs, and health and welfare plans as well.
Okay, and so specifically, you've got a duty to act on behalf of others. But kind of what's the standard here? Is it a high standard? Is it a low standard if I have to act on behalf of others?
Yeah, so the courts have called it the highest standard known to law. And generally, fiduciaries are subject to duty of prudence, to act prudently, follow a prudent process, to act loyally, and with an eye single to those participants and beneficiaries that they're acting on behalf of, and to avoid things that we call prohibited transactions.
So under ERISA, if we're a fiduciary, we've got a couple of obligations. We've got both a standard of care and we have prohibitions on things that we are allowed to do.
That's right. That's absolutely right.
And so in the context of this rulemaking, we fear that, or we think that DOL is likely to expand the scope of who becomes a fiduciary. What area of becoming a fiduciary do we think they're going to focus on?
Sure. So ERISA Section 321 has three prongs. You can be a fiduciary by way of providing, management or administration to a plan. You could provide, you can be a fiduciary by providing investment advice, or by managing a plan's assets, and we're really focused on that second prong, the investment advice prong, and this is where we expect DOL to expand the definition of who's a fiduciary there.
Oh, awesome, George. Thank you for providing such a great overview of how someone becomes a fiduciary. Come join us next time for another segment here at the Investment Advice Hub.